The H1B Guy here, and today, employment-based second preference, national interest waiver, EB2 NIW, what you need to know. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention that H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment based immigration benefits. If I can help you, please reach out. I'd love to hear how. And you can book an appointment directly with me via the h1bguy.com. Today's post is brought to you by Synthesis and Pat to Canada, the ideal plan B for high skilled immigrants currently located in the U.S. whose status may be uncertain, by PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys navigating the complex PERM recruitment ad phase of the labor certification process, and by Mob Squad. Are you a technology professional facing U.S. work visa related challenges? Don't leave your fate up to chance. Our partner Mob Squad has a solution. Join the squad. Well, for individuals seeking to work in the U.S. on a permanent residence basis, the employment based second preference visa, known as EB2, offers an excellent opportunity for those that qualify. This visa category is designed for professionals with advanced degrees or exceptional ability in their respective fields. In today's post, I'll cover the eligibility criteria and documentation requirements for securing employment based immigration second preference EB2 with national interest waiver. Let's start with the key qualifications. Advanced degree. Qualify for an employment based second preference visa based on advanced degree, your prospective job must require such a degree and you must possess the degree or its foreign equivalent. In addition, you must demonstrate 5 years of progressive post degree work experience in that field. It's also essential to meet any other requirements specified on the labor certification applicable as the priority date. Supporting documentation. When applying for an employment based second preference visa based on an advanced degree, you will need to provide documentation that substantiates your qualifications. This may include an official academic record validating your U.S. advanced degree or its foreign equivalent. Alternatively, you can submit an official academic record demonstrating that you hold a U.S. degree or its foreign equivalent, along with letters from current or former employers attesting to at least 5 years of progressive post degree work experience in your field of expertise. These are known as experience letters. If the job you're applying for typically requires a doctoral degree, it is necessary to possess a U.S. doctorate or its foreign equivalent. Exceptional ability. Another pathway to eligibility for employment based second preference visa is demonstrating exceptional ability in the sciences, arts, business. Exceptional ability is defined as a degree of expertise significantly above what is ordinarily encountered in these fields. You must also meet any specific requirements mentioned on the labor certification. To establish exceptional ability, it is essential to meet at least three of the following criteria. One, official academic record. Provide evidence of a degree, diploma, certificate, or similar award from college, university, school, or other institution of learning that relates to your area of exceptional ability. Two, work experience. Obtain letters from current or former employers documenting at least 10 years of full time experience in your occupation. Three, professional license or certification. Present a license or certification applicable to your profession or occupation. Four, salary or remuneration. Demonstrate evidence of receiving a salary or other forms of remuneration that highlight your exceptional ability. Five, professional association membership. Provide documentation of your membership in relevant professional associations. And six, recognition for achievements. Gather evidence of recognition and significant contributions to your industry or field by peers, government entities, professional organizations, or business entities. Ability to pay. As part of the employment based visa process, your employer must demonstrate their ability to pay the offered wage from the priority date and continue to do so until you obtain lawful permanent resident status. The purpose of this requirement is to ensure that you'll be adequately compensated for your work. To establish that your employer's ability to pay, various forms of financial documentation can be submitted. These may include an annual report, federal income tax return, or audited financial statement. By presenting these records, the employer can demonstrate their financial stability and their ability to fulfill their wage obligations. Labor certification. In most cases, employment based second preference petitions must be accompanied by certified application for permanent employment certification from the Department of Labor. This application, typically submitted as a Form 9089, validates that the employer has made efforts to recruit U.S. workers for the position but has been unable to find qualified individuals. However, it is important to note that the DOL provides a blanket Schedule A certification in certain situations, which can expedite the process for some applicants. And the labor certification types: general permanent labor certification. Your employer must obtain a certified application for permanent employment certification from the DOL before filing the Form I-140 petition for alien worker with USCIS. And Schedule A blanket labor certification for those with exceptional ability as defined by the Department of Labor, widespread acclaim and international recognition, or certain professional nurses and physical therapists. Their employer submits the petition to USCIS with an uncertified Form 9089 for consideration as a Schedule A. And then that brings us to National Interest Waiver. It's worth noting that you may request a waiver of ability to pay requirement in the national interest through the petition filed with USCIS. This waiver is applicable when you apply for a national interest waiver, which waives the job offer and eliminates the need to demonstrate the employer's ability to pay the wage. The national interest waiver is typically reserved for individuals who can demonstrate that their work is in the best interest of the U.S. It may be applicable to those with exceptional abilities or whose work has substantial merit and national importance. However, it's important to consult with an immigration attorney to determine your eligibility for a national interest waiver. Per USCIS policy manual, under National Interest Waiver of Job Offer, quote, since 1990, the Immigration and Nationality Act, INA, has provided that a person of exceptional ability may obtain a waiver of the job offer requirement if USCIS deems such waiver to be in the national interest. A subsequent technical amendment extended the job offer waiver to certain professionals. The waiver provisions apply only to second preference EB2 classification for members of professions holding advanced degrees or persons of exceptional ability. This waiver of the job offer is known as the National Interest Waiver. A petition filed with a request for a national interest waiver on behalf of a person does not need to be supported by a job offer. Therefore, the person may file as a self-petitioner. A waiver of the job offer also includes a waiver of the permanent labor certification requirement. In support of the petition, however, the petitioner must submit the employee-specific portions of the permanent labor certification without DOL approval. So, qualifications for a national interest waiver are not defined by statute. Instead, USCIS considers the three factors below, and that those seeking national interest waiver may self-petition. They do not need an employer to sponsor them. So, the three factors USCIS considers for national interest waiver: one, the proposed endeavor has both substantial merit and national importance. Two, you are well positioned to advance the proposed endeavor. And three, on balance, it would be beneficial to the U.S. to waive the requirements of a job offer and thus the labor certification. So, qualification for EB2 classification as a member of the professions holding an advanced degree or as a person of exceptional ability does not automatically mean that the person qualifies for a national interest waiver. Regardless of whether the person is an advanced degree professional or demonstrates exceptional ability, the petitioner seeking a waiver of the job offer must not only demonstrate eligibility for the classification, but must demonstrate that the waiver itself is in the national interest. For the exceptional ability, the INA requires that all petitions for a person of exceptional ability show that the person's presence in the U.S. would substantially benefit the national economy, cultural and educational interests, or welfare in the U.S. in the future. Even if the petitioner demonstrates such an exceptional ability, if the petitioner is seeking a waiver of the job offer, the petitioner must also demonstrate the additional requirement of national interest. Neither the INA nor the regulations define the term national interest. The burden rests with the petitioner to establish that the waiver of the job offer requirement is in national interest, and USCIS considers every petition on a case by case basis. When a petition is denied because the petitioner has not established that granting the waiver is in the national interest, the decision must include information about the appeal rights and the opportunity to file a motion to reopen or consider. If you believe that EB2 NIW is an option for you, as I previously mentioned, you need to consult with an immigration attorney. I know that many of you have successfully pursued the EB2 NIW path and were able to cut down on your green card wait times. In closing, the primary benefits of pursuing an EB2 National Interest Waiver NIW is the exemption from the requirement of a job offer and the ability to demonstrate an employer's ability to pay the offered wage. This waiver provides a unique opportunity for individuals with exceptional abilities whose work holds substantial merit and national importance to obtain an employment based second preference visa without the need for a specific job offer. By securing an NIW, applicants have greater flexibility and autonomy in their career paths, as they are not tied to a specific employer or position. This allows them to pursue their research, innovations, or contributions in their respective fields, benefiting both the applicant and the U.S. as a whole. The NIW opens doors for individuals to make significant contributions to the U.S. and fosters a more streamlined immigration process for those who possess exceptional abilities or hold work of national significance. For the full post on EB2 NIW, what you need to know, please check out the H1BGuy.com. And a reminder that today's post is brought to you by Syndesis and Path to Canada, the ideal plan B for high skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H1B denial or OPT expiration, don't get caught off guard. Once you have a plan B, and Syndesis and Path to Canada are your answers. They'll gladly help you navigate the process, and if you'd like to find out if you qualify, please be sure to use the link in the video description below. Someone from Syndesis or Path to Canada will be in touch. And by PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys navigating the complex PERM recruitment ad phase of the labor certification process. If you're looking to reduce your costs and overhead associated with PERM labor certification recruitment advertising, let PERM-Ads.com help you. And by Mob Squad. Are you a technology professional facing U.S. work visa related challenges? Don't leave your fate up to chance. Our partner Mob Squad has a solution. Mob Squad helps technology professionals facing U.S. work visa related uncertainty remain working with their current U.S. employer nearshore from Canada, as well as technology professionals from around the world who are seeking to find a rewarding opportunity in North America. Through their partnership with the Canadian government, they can obtain a Canadian work permit for you and your spouse in as little as 6 weeks. So whether you're looking to stay working with your current U.S. company or you want to find a new opportunity in Canada, please find out how the team at Mob Squad can help you via the link in the video description below. Join the squad. Just wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. I really appreciate your support. The H1B Guy, your global source for all things H1B.